Okay, everybody, this is a little presentation that we're doing on bankruptcy. For paralegal students, okay? And so what we're basically going to be talking about is some basic concepts of how to do a bankruptcy. In other words, a lot of people in a lot of firms are involved in preparing bankruptcies, and oftentimes in the office of an attorney, the paralegal is the one that's responsible for pulling all the information together and preparing this bankruptcy form that needs to be filed with the federal court. Now, there's some disclaimers that we have to make on this, and this is that this class is basically being prepared for students that are going to be taking an online class on bankruptcy from Ivy Tech, and it involves Indiana law. So if you're thinking, well, I live in California, this may not be what you're looking for. Basically, this is going to be focused in on the assumption that these paralegals are going to be working in Indiana using Indiana exemptions. So that's important. The other thing is that I've worked in this field for 25 years, but things are constantly changing. And so as far as being a guide to you to help you fill out your bankruptcy, this is not legal advice. This is no way an attempt to help you fill out your bankruptcy. This is really just an effort to help my students better understand the material that they're getting on the internet without the benefit of a face-to-face lecture in a classroom. So that's what this is for. So let's get started on this. A lot of times the first thing that we talk about when we start on a class like this is the history of bankruptcy. And so that's an important point. And so one of the things to consider on that is that over centuries there were a lot of different ways that provisions were made for people who had some kind of catastrophic event in their life. One of the ones that we always point to is in the Bible, for example. There is some consideration in there of what they call a year of Jubilee, which was at the end of 50 years, everybody got together and said, okay, any debts anybody owes, they're over. Starting from scratch. Everybody gets a fresh start. So these words fresh start are very, very important in discussing bankruptcy. This is one thing that is carried down through for centuries. And so that is very important as you learn this fresh start. Okay? Well, you know, in fairness, a lot of people I know who were raised in a conservative family have the attitude, well, bankrupt people that file bankruptcy are just a bunch of freeloaders, and they're trying to figure a way to wiggle out of their debts. Well, that is true sometimes, but it's a very small percentage. Most of the time what you're finding with people like this is that they have some kind of catastrophic thing that you will very rarely see happen to people. So it's one of the things that you need to keep in your mind is try to keep an open mind. If you're going to work in this field, you're going to work with people from a lot of different backgrounds, a lot of different things have happened to them. For example, they may have had a death in their family. They may have been doing just fine, but they were living like paycheck to paycheck, like a lot of people do. An important member of the family that had a good job, that took care of the family, paid the bills, died. Now suddenly they're faced with all this debt, especially maybe catastrophic medical bills, which is also further down the list. This person, not only did they die, but they lingered, had maybe cancer or some other catastrophic disease, tons and tons of medical bills, no way to pay the bills, so there's no choice but to file bankruptcy. In fact, An inside story among lawyers is that long before Obamacare, bankruptcy was the health care program of choice for a lot of common everyday Americans. In other words, it built up a large quantity of medical bills and filed bankruptcy. So nobody got anything except the people with insurance turned around and had to help pay the cost of the people who filed bankruptcy. Another common group is divorce. There's a lot of people that seem to be able to work things out and get along real good with two incomes, but the problem that happens is they cannot work things out to pay their bills as a single person after having lived together as married for many years. And so in the chaos of getting divorced, then a lot of the bills go unpaid. I've even seen cases where they divide the bills up. One person is responsible, tries to pay their share of the bills. The other person is irresponsible. That's why they got divorced. And the next thing you know, they're both bankrupt. So it's a bad situation. A thing that you need to understand about divorce is that just because you divide up the bills in your divorce, the creditor is not a party to that agreement. So the creditor can look to both people to pay those bills. So even though you agreed, let's say, to pay for the car, and the ex-wife agreed to pay for the house, or vice versa, and okay, you go along, you pay the car off, everything's cool, here comes the bank wanting to know why you weren't making the house payment. And that happens all the time. I mean, it happens most of the time. There's a lot of these kind of issues. So, divorce causes a large number of bankruptcies. It's due to unintended consequences. Most of the people involved have the best of intentions, but something happens and it just doesn't work out. Another situation that we have is unanticipated unemployment. It's just like our economy's been here lately. You'll run along, it'll be really good for a long time, and suddenly the bottom drops out of everything. So it can be, really bad that way. Well, okay, so we want to keep in mind that health care is one reason for bankruptcy. Death in the family or divorce. Big reasons why we are confronted with bankruptcy. So these are all what we call causes of bankruptcy. So the main thing that I urge you is just to keep an open mind and don't assume that everybody is trying to take advantage of the system. It's your job. If you're representing debtors law firm, then you need to be at least open-minded toward the debtor. If you're working in a creditor's law firm, I'm sure you're going to be inundated with these views that everybody is willfully trying to get out of paying their debts, and that's just not true in most cases. Large percentages of cases are for the reasons that I've given you. The main thing about bankruptcy is it's about debts. It's about debt collection. So we want to put something up here about that. In other words, it's what we call, you have what we call an estate, and that estate is the same estate whether you're living or dead. And in that estate, you have a certain amount of debt, and you have a certain amount of assets. And so what is happening is that you have a certain amount of exemptions. The thing about exemptions is this varies from state to state. Now there is a federal exemption, and a lot of states just say, okay, we'll just adopt the federal exemption. Indiana is not one of those states. Indiana has opted to do what Congress gave them the right to do, and that is to create their own exemption statute. So that's what they have done. So that's something that you really seriously want to consider, is that I've seen a lot of people filing papers with me as an assignment, a written assignment, and they're trying to opt for the United States Code federal exemptions. You cannot do that in Indiana. So one of the things we're going to talk about in one of these later presentations that I'm going to do for you is the way that you have to do the exemptions in Indiana. So it's important. That's something that we will stress time and time again. So what you do is you take the debts and you deduct them from the assets, and you apply the exemptions, and then if there's something left, then it has to go on the debts in some way. And we'll talk about another part here real quickly. One of the things we said in terms of debtor relief is the fresh start provision. That's the whole idea. Give everybody a fresh start to start all over and start clean. But one of the other things that we have to consider is what we call marshaling assets. Okay, and what that means is that we have to look at the assets and decide whether or not this person can pay anything on debts, whether they should file what we call a Chapter 7, which is a full liquidation, or whether they should file a Chapter 13, which is a wage earner plan where they pay something on their debts. One thing is that when a petition is filed, there is what we call an automatic stay. Automatic stay. And the automatic stay means that nobody can sue you while your bankruptcy is pending. So what that means is that you are protected, that anything that happens with regard to your debts has to be taken care of through the bankruptcy court. Nobody can keep pro-supping you, nobody can take you to court, nobody can have you arrested. All of this has to proceed through the bankruptcy court. Now, basically, when we get into this thing about exemptions, then I'm going to go into a different presentation. And so what we're going to do is we're going to conclude with these comments here for this section. So this is just a kind of an introduction to taking my class, Paralegals who are learning to handle bankruptcy. So the class Bankruptcy, which is Para 212, Ivy Tech, something that you should familiarize yourself. Feel free to watch this video as many times as possible. If you have questions, you can always contact me. My home email address is robdaywalt@me.com. Thanks.